your right hand, sir. State your name, please.
My name is Paul Durant.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I swear.
Please tell the jury your name and where you're employed.
My name is Paul Durant. I'm a special agent with the FBI assigned to the Johnson City RA.
Okay. And is your last name spelled Durant?
Yes.
Okay. How long have you been employed in that capacity?
I've been employed with the FBI for about 5.5 years.
Okay. And you stated your title was special agent?
Yes, ma'am.
Okay. Can you tell the jury a brief description of your current duties with the FBI?
So as a special agent with the FBI, I'm primarily assigned to investigate crimes against children. So anything with sexual exploitation, kidnapping, human trafficking, things of that nature.
Okay. Can you give the jury a brief summation of your education?
Yes. So I have a bachelor's degree in finance that I attained from the University of Central Florida. I have a second bachelor's degree in biomedical science, which I also attained from the University of Central Florida.
Okay. And during the time you were employed with the FBI, were you asked to aid in the investigation of missing child Evelyn Boswell?
I was.
What were you tasked with doing at that time?
So the FBI in general was tasked with supporting our local and state partners. We did anything from interviews to phone extractions to assisting interviews outside of the state. Primarily, my responsibility was reviewing all of our documentation and looking for any patterns and things like that.
Okay. When you say documentation, are you referencing digital documentation or other items?
Mostly digital documentation, as well as like interviews and notes and stuff like that from the other investigative agents.
Okay. And from the time you first assisted until now, have you continued to receive training in the area of forensic examination of digital devices?
Yes, I have.
Okay. Can you tell the jury briefly what type of training you've received?
I received training through the FBI as part of the Computer Analyst Response Team technician, as well as the Digital Evidence Examination technician.
Okay. When you say response team, what does that mean exactly?
Essentially, like any of the response teams, are teams that can be deployed. We can go to search warrants. For example, like we call it CART for short. The CART team would join investigative agents in the field. We would examine any computers that were on and available during the time, as well as cell phones, and then bring those back to our office for further examination and extraction.
So CART is short for Computer Analysis Response Team?
Yes.
Okay. And how long have you been a part of that team?
I believe about 3 years now.
Okay. And have we sufficiently covered your training regarding digital evidence, or is there anything else you would like the jury to know?
So that's the majority of my training with digital evidence.
Does the FBI utilize forensic digital evidence equipment to aid you in your investigations?
Yes, so we have several different forensic softwares that are FBI approved, as well as specific devices to help us extract and image electronic devices.
Okay. And we'll briefly go into what the FBI utilizes. When it comes to cellular devices like telephones, what would a digital analysis entail regarding cell phones?
So regarding cell phones, we do what we call extractions of cell phones. So we use a forensic software to extract different data from the cell phones. There's several different extraction methods that you can use. 3 main ones. The first one is kind of a logical extraction. Essentially what that does is we ask the cell phone, what can you provide us? And the cell phone will provide us X data. The next analysis that we can do or extraction that we can do is called a file system extraction. That's kind of where our software goes into the cell phone and then tries to pull as much data as we can from that cell phone. The last extraction that we can perform is called a physical extraction. Essentially, that is a bit-for-bit copy of whatever that electronic device is.
Okay. And just so we action, do you mean taking the information off of that device to be able to utilize what you're looking at?
By extraction, yes, we don't take anything physically off of that device, but we make a copy of those items on that device and put it onto another, like electronic storage media.
Okay.
So we're not changing anything on the device.
Okay.
We have different methods that ensure that we have made a what we call a forensic copy of that device.
So it's essentially a copy of what was on that device.
Correct.
Okay. Can you, and you've done this a little bit, can you tell the jury how that's done? How does a technician take that copy from a cellular device and put it into another place?
Yeah, so we'll connect that electronic device up to like our computers and our forensic extraction software. We use things like write blockers to ensure that no information from our devices or our computer is transferred over to the cell phone. Once the data is extracted from that device, we'll go ahead and ensure that a copy has been made, a forensic copy. We do that through hash verification. There's two different ones that we use. One is MD5 hash, and the other one is SHA-256 hash. Essentially, what a hash is like a fingerprint of that electronic device. It just shows that we made a exact forensic copy of that content.
Okay.
Once that content is created, we transfer that to another electronic storage medium, whether that's a USB drive, whether that's just any kind of external media drive. And then we run a hash verification to ensure that that copy was not altered during that transfer process.
Okay.
That is typically what is done best practice.
Okay. Can you tell the jury what types of... Have just a moment, Your Honor. Okay. Agent Durant, have you previously performed digital analysis of cellular telephones?
Yes.
Have you previously performed analysis of social media extractions from search warrants?
Yes.
Okay. Your Honor, at this time, we would ask that he be made an expert in the area of forensic analysis of digital devices.
Yes, Lord, our witness. Sir, how long have you been employed by the FBI?
I've been employed by the FBI for about 5.5 years, since September of 2019.
And in that time, how many times have you been qualified as an expert in court? Or have you?
I don't believe I've been qualified as one as per a digital evidence extraction. So I've been qualified in the areas of child investigation, like child crime investigations.
But as far as digital forensics, you have not been qualified previously?
No, I don't believe so.
And if we could go back to your training, if you would go over that again with me, specifically as it relates to digital forensics, what training do you have?
In terms of digital forensics, so I have two trainings that I attended to. One was the computer analyst response team technician. Essentially, that is the one that I explained, that you kind of go out there and you're able to collect those electronic devices and then kind of take them back, prepare to do like the digital extraction portion.
Okay. And how long was that course?
So that course was 2 weeks.
Okay. What other training do you have?
So I also am authorized as a digital evidence examination technician. Essentially what that one is that's the actual like extraction process of being able to extract the data and search through the data for information, evidence of crime.
Did you go to a course for that?
Yes.
How long was that course?
It was about 2 weeks.
About 2 weeks.
Yeah, so both courses were 2 weeks long.
You have specialized training in the software you're using?
In the software?
Yes.
Yeah, we were shown how to use the software, and we use that software in our cases.
Okay. When you say you were shown how to use the software, what type of training do you actually have with the software?
That was part of that training program where we actually get the software, we review what the software can do, and then we use that in order to extract digital evidence.
And your formal education background is a degree in finance and a degree in biomedical science.
Yes.
Do you have any formal education as far as college or anything like that as it relates to digital forensics, downloading phones, so forth?
No college experience with that, no.
Okay. Thank you. We approach.
Agent Durant,
Yes.
during the course of your career, how many of these digital forensic analysis have you performed?
I've extracted and analyzed, I would say, approximately 30 cell phones or mobile devices, kind of cell phones, iPads, stuff like that. And in terms of computers, probably about another 20 for computers in terms of like laptops, external hard drives, and things like that.
General, what field were you asking if we have him qualified in? Specifically?
In forensic analysis of digital devices.
Will overrule the defendant's objection. He'll be declared to be an expert in forensic analysis of digital devices
Thank you, Your Honor.
based on his training and his experience.
Okay. So we're going to back up just a few questions back to the cellular. I believe you were testifying as to the cellular phone analysis and software that the FBI used. I believe we talked about the types of data that can be, and I think that was actually my next question. When we're talking about cellular phones or cellular devices, can you tell the jury what types of data can be obtained from an extraction of a cellular device?
Yes, so extractions of cellular devices can provide a lot of different data, such as images, videos, text messages. You could do web searches, GPS. Pretty much anything that could be stored on a cell phone can be found through an extraction of the cell phone.
Okay. And is every cell phone the same, or are you able to obtain duplicate copies of, like, say, two individuals have Facebook on their phones? Do you always get full records on each device, or can that be different depending on the device itself?
It really depends upon the device, depends upon what the software update is, if some have older software versus newer software updates. There's a lot of different factors that can play into what can be extracted from an electronic device. In terms of social media, when you're extracting social media information from the device, it's only the information that is found on it. So a lot of social media companies will store stuff in like the cloud or off of your cell phone. So when you do an extraction, you may only get a couple of days of social media conversations. You may get more, you may get less. You may not get any at all. It really just depends upon the extraction method used and the data that was stored on the actual electronic device.
Okay. Do you also, as part of your training and experience, also analyze social media extractions based on search warrants?
Yes.
Okay. Do those tend to offer more information than pulling social media directly from a cellular device?
Yes. So information that you obtain through a search warrant for a social media company is going to have a more complete record of the conversations and the activity on that account, as opposed to one that is pulled from an electronic device.
Okay. And can you tell the jury why that is?
So kind of like I stated before, the information that you're going to get from an extraction of an electronic device is only going to be the information that's found on that device when you do the extraction. So so one of the things that we do when we do an extraction is we put, like, for example, the cell phone in airplane mode. And in airplane mode, the cell phone is not able to communicate with any of the servers, the social media servers. So it's just whatever's on that device at that time is what you can get. However, when you do legal process through social media, they have access to all the information that they would store. All that information that would be on a cloud account can then be provided to law enforcement through legal process.
Okay. You may have already asked this when the judge asked you these questions. Have you previously performed a digital analysis of cellular telephones?
Yes.
Have you also performed analysis of computers?
Yes.
And what about social media extractions from search warrants?
Yes.
And were you provided with digital extractions in the case we're here on today?
I was.
Okay. Do you know what types of digital extractions you were provided with?
Yes, so the two main ones were a few cell phone extractions as well as social media search warrant returns.
Okay. Were any of those directly linked to the defendant, Megan Boswell?
Yes.
Okay. What were you specifically asked to do with the information that you were given?
I was asked to review the social media search warrant proceeds from Ms. Boswell's Facebook account and Instagram account.
Okay. And tell us what proceeds are.
Proceeds, so when you submit a search warrant to social media companies, essentially what they send you back is the proceeds of that warrant. So when I say search warrant proceeds, I mean all the information that's Facebook or Instagram or any social media has provided the law enforcement officer.
Okay. And were you actually able to perform an analysis on the defendant's social media that was provided to you?
Yes, I reviewed both the Facebook and Instagram accounts.
Okay.
Ladies and gentlemen, I'm going to go with the officer.
Everyone stand, please. You may be seated. Thank you.
All right. You decide want to be heard from.
Your Honor, if I could speak briefly. Well, first, the state of Tennessee has fulfilled the notice requirement by filing a written notice of intent to introduce these documents, and we were not at any time notified by the defense that they were going to be opposing these. But also under Rule 902, it falls under a self-authenticating documents because it is records of regularly conducted activity, and the case law is clear that a self-authenticating affidavit is sufficient on being able to bring these records in.
Judge, as it relates to pretrial notice, my reading of Rule 12 of the Tennessee Rules of Criminal Procedure basically sets out 5 things that must be raised pretrial: defects in the institution of the prosecution, defect in the indictment, so forth, motion to suppress, request for discovery, and a motion to sever. None of those things include this. I've objected because that affidavit is not an affidavit; it's a statement, and it should be sworn to in front of someone who is qualified to give an oath. And for it to qualify under 902, I think it has to be an actual affidavit sworn to by someone qualified to give an oath.
Your Honor, if you would like, we would be happy to provide you with a case that allows for this document to be sufficient. It's on page 16.
Could I see it?
Yeah.
So you get my copy.
You have a copy for the defense.
I'm trying to find it. Yep.
looking at the written notice, the certificate of service signed by General Harper says that it was emailed to Defense Counsel on the 31st day of January 2025. It was filed February 3rd with the clerk's office. But it included a copy of this certificate of authenticity and domestic records of regulated conducted activity. Mr. Scott is correct that there does not appear on this document a notary from the state of California. I do note that in every other respect that the certificate of authenticity complies with both rules 803, 6, and 902, 11. And the certificate of authenticity declares under penalty of perjury that the certificate is true and correct to the best of this person's knowledge. And it has the logo of Facebook on the document itself. And looking at the case that was handed up, State versus Benitez, 2022 Westlaw 123-1075. Quoting State versus Ferguson, 741 Southwest 2nd, 125, that the circumstances must only show with reasonable assurance the identity of the evidence. And the court satisfied that this certificate complies with that standard. So I'm going to overrule the objection and the state will be able to continue. We'll take about 10 more minutes of break. So
Thank you.
Thank you.